And in general, there are three major tasks that reform of the statute should accomplish. And as I say, there's a certain amount of consensus on at least some of these. The first is with respect to Congress, the act should severely constrain or maybe eliminate completely Congress's ability to reject a state's votes based on Congress's disagreement with the voting process that took place in the state. When Congress meets on January 6th, it's not a national recount board. It's not a court to second guess court decisions that have been made by state and federal courts. And so this means various reforms to the act that make it much tougher for members of Congress to object. Right now, it takes only one senator and one representative to trigger an objection process for receiving the votes from a particular state. That needs to be raised to maybe 25%, 33% of Congress being needed to object before an objection becomes a valid objection that starts the debate. Maybe a supermajority requirement before any objection can actually be accepted, that is, votes from the state thrown out, and also sharply limiting the grounds on which Congress can object. And as I say, there's significant consensus in the bipartisan group of senators that we've been working with to take a number of these steps. Ned and I would probably go quite far in this direction and eliminate any role for Congress in second guessing the votes from the states based on the voting processes that took place there. But there will be movement in that direction, wherever the Congress exactly ends up. The second thing is with respect to the states, much of this is already the case, but it's not clear. So the act has to make very clear that states have to conduct their election processes and any processes for resolving disputes about the election through laws that are enacted in advance of the election. Legislatures cannot come in after the votes have been cast and decide that they now are going to appoint electors themselves. That's already forbidden in current law, but that needs to be made more clear. The act has to also clarify which institution in state government has the power to determine the lawful winner of the election. So that if we end up in a situation in which different parts of the state government attempt to send different slates of electors, the governor sends this slate, the Secretary of State certifies a different slate. The act has to make clear in advance which of these Congress is supposed to count. And finally, there's this provision that Peter referred to called the failed election provision, which goes back to 1845. I called it a loaded weapon in the system. It gives state legislatures the power to appoint electors if the election has failed. That's the term of the statute in their state. The provision was there to deal with a potential natural disaster or something like that that precluded voting in the state. But it's not specified in the law currently what a failed election is. And we now face a risk that legislatures are going to claim if there's something they don't like about the voting process, if the courts are taking a long time to resolve the outcome, that the election has somehow failed. That's a very dangerous provision. And so Congress, as part of reforming the statutes that regulate the presidential election process, needs to close that loophole and make it clear the very, very limited circumstances, such as a natural disaster, in which the state legislatures might be able to appoint electors if no election is actually possible on election day. The third thing, which is the most difficult issue here in the reform process, is there needs to be an additional role for federal courts laid out in the statute, a role that's very limited, very minimal, but is there to ensure at the last stages of the process that if we face the situation of, let's say, recalcitrant governors who refuse to send to Congress the slate of electors that have been appointed in that state, a scenario we now worry about, that there's a recourse for that in the federal courts. So removing Congress from the role of second guessing the state processes, making clear that the state has to function according to law established in advance of the election, making clear which part of state government has the final lawful authority, and a backstop role or an insurance role for federal courts. In our view, those are the three key elements in reforming this statute. But as Mike said, this is an incredibly urgent task right now because we cannot go into the 2024 election with all the legal uncertainties that currently surround the basic legal framework for dealing with the presidential election at the national level.
Now, and in order to make that point, I'd like to go back into history. Again, the statute that needs to be fixed is this 1887 statute called the Electoral Count Act. And it was enacted in 1887 in the wake of the disputed election of 1876. So that was a decade earlier. It took Congress 10 years to adopt a legislative remedy, despite the urgency that was recognized then. That was very risky for reasons that I'll explain, and we don't want to roll the dice again in the same way, and that's why we have to fix this statute now and not wait till after 2024. So kind of to set the stage for this point, many historians and political scientists, election law scholars think that we are living right now in a period of intense political polarization, not unlike the so-called Gilded Age of the 19th century in the aftermath of Reconstruction. That was a period also of intense polarization, and the disputed election of 1876 and the political conditions at the time resemble, unfortunately, what we're living through now. Most of us, grew up in the middle of the 20th century, blessed with low polarization, kind of a period of American history in terms of political contestation that was anomalous relative to the kind of contestation that we now have again. And it's dangerous to go back to those 19th century conditions. The thing that I am worried about, all of you all remember your SAT analogies, this is to that, like so and such is to such and such. I'm really worried that the relationship of 1872 to 1876 is analogous to what we just went through last time with 2020 and what we could face in 2024. What do I mean by that? Peter already talked a little bit about 1872, Horace Greeley died, but there were other disputes that were going on then, because as Reconstruction was ending, there was huge political contestation in some of the southern states like Arkansas and Louisiana, to the point where Congress disqualified electoral votes from those two states. It didn't really matter because Ulysses Grant won a landslide, but that election in and of itself showed the ambiguities and flaws in the constitutional structure for counting electoral votes. The 12th Amendment, which is the relevant constitutional law, is very vague and ambiguous. It just says states will send electoral votes to the president of the Senate and they shall be counted using the passive voice that my 6th grade English teacher said never to use if you want to be clear, but our Constitution does that. And so any clarity has to be supplied by statute. Congress, and this is to the point about the urgency of the situation and the difficulty of the congressional hurdle and why it's so important to get Congress to act. Congress debated between 1872 and 1876 on what a statutory reform should look like. I mean, they knew the need for it, and they didn't just ignore it, but given bicameralism, given polarization, they could not get a statutory fix across the finish line before the major disputed election of 1876. And that was, our minds are seared by the violence in the Capitol of our January 6, 2021, that was awful. But from a governance point of view and a constitutional stability point of view, our experience was actually less dangerous than what happened in 1876. And this is why Peter's slides are so important and so relevant. I'm not going to go into all the details of just how precarious the fight between Hayes and Tilden over the 1876 election was, except to say that it was the members of Congress that drew their pistols when they were counting electoral votes. And the Speaker of the House had to call the sergeant in arms out against members of Congress, not just people who were, citizens who were protesting. And we almost had a second civil war over the outcome of the election. Again, we could discuss it in Q&A how it got resolved, but after the crisis of 1876, having failed to adopt the statute ahead of time, Congress said, well, we've got to have the statute. It's really apparent we can never go through this again. And yet they went through 1880 again without a statute. They went through 1884 again. And it was only when they were coming up against the 1888 election that they said, we cannot roll the dice again. And 1880 and 1884 were quite close. Fortunately, it didn't spin out of control. But every time you go into a presidential election without a good statute, you are risking huge constitutional calamity. And so that's the kind of risk that we are facing now if we don't repair the statute. The other point that's useful, I think, from a historical perspective, why do we have such a bad statute at the moment that needs the kind of repairs that Rick was talking about? It's because when they finally got around to adopting the 1887 statute, that was the best that they could do. They knew it was ambiguous. They knew it was not perfect. A political scientist at that time said it was gobbledygook and he didn't understand it. Kind of true, but they thought, well, something is better than nothing. And maybe that is true, but they were hoping that some future Congress before the next emergency occurred would provide the kind of clarity that Rick is talking about, so that they wouldn't leave these holes and these ambiguities that we are confronted with.
If you're not frightened by what you've heard, you should be. If you looked at Peter's slides and said, oh, that's from a science fiction movie, fortunately, we live in the real world where that can't happen. The fantasy is on your end of thinking that it can't happen. I, as a lifetime scholar of democracy, I'm not a legal scholar, I'm a political scientist, but it's been my privilege to work with Rick and Ned. Believe there is a very serious chance that we will suffer a breakdown of American democracy around the presidential electoral process in 2024. If it happens, if we cannot clearly determine who the winner was with some kind of legally recognized legitimacy, even if we still have one party or the other denying the legitimacy, the levels of violence, I think, will exceed what Peter was envisioning. And the damage to the American economy could well be what Peter was envisioning. The existential self-interest of American business in doing what can be done statutorily to construct better guardrails and better clarity around this process is, to me, overwhelming, simply overwhelming. Business often asks itself, what are the risks on the horizon and how can we guard against them? Usually, this risk reduction involves business strategies that are largely, unique to the corporation. But in this case, I think there is something that American business can do and really must do to ensure that some of those extremely rickety and virtually non-existent by now guardrails around our electoral process can be at least somewhat fortified. Fixing, amending the Electoral Count Act and the Failed Election Act, hopefully as well, is not going to solve every problem and vulnerability. But, we have a moral and political obligation to ourselves and to our country to do what can be done. And I think that there is, in these coming months, Ned and Rick are closer to the process, so they can comment on it. There's a window of opportunity, and it feels like we're somewhat close. And it would just be tragic. It'd be a tragedy if we lost this moment. And if the worst comes to pass, and we do lose this moment, I think history will damn every one of us who heard the preceding three presentations or things like it that have been written and talked about, and didn't do what we can to bring this about. I'd like to just make one other point, which Ned and Rick can react to if they want. I think our best hope is going to be to construct these guardrails and remove these loaded guns through statutory reform, and then hope as much as possible that the courts, the federal and state courts, will be, the arbiters of any disputes. And I think it should be obvious that we may need to give that judicial process more time than it now has, given the date on which certification of a state's electoral votes under the current, quote, safe harbor provisions needs to occur. I personally hope, I don't know where this stands, Rick and Ned could comment on it, that the reform of the Electoral Count Act will also move the safe harbor date back. I believe it was December 8th in 2020. Is that right, Rick and Ned? And it'll be a similar date probably in 2024. Move it back about 3 weeks or something. It doesn't sound like a huge amount of time, but it might give more time for disputes around state election results to be resolved in the courts so that they don't contaminate the national process. But you do what you can at any moment in time to try and reduce risk, and anything that can be agreed upon in the amending of these acts is going to be much better than nothing at all. And I hope members, reasonable members of Congress of both parties, will recognize that.